Students, today we are going to discuss modes of creation of agency. An act done by agent on behalf of the principal binds the principal towards the third person. Following are the modes of creation of agency under which the agent has the power to bind his principal. Modes of creation of agency. First one, by the express or implied agreement. Second, by agent's authority to act in a situation of emergency. Third, by the law of estoppel. Fourth, by ratification. And fifth, by presumption of agency in husband-wife relationship. First one, by express or implied authority. As per section 186 of the Contract Act, an authority may be express or implied. Terms express and implied authority are defined under section 187 of the Indian Contract Act 1872. An express authority is an authority when it is given by words spoken or written. Implied authority is to be inferred from the circumstances of the case, means the authority which arises from the conduct, situation or relationship of the parties. Extent of implied authority under section 188. In Ishak versus Madan Lal explains agent's implied authority which depends on the nature of transit. The plaintiff in this case was the potato dealer at Uttar Pradesh, sold and dispatched the wagon of potatoes to the defendant, a dealer at Madhya Pradesh. The defendant refused to take the delivery of the goods. The plaintiff sent his Muniyam, that is agent, to MP and authorized him to sell the potatoes at the price which he chooses. The agent contacted the other dealers and the defendant in the trade. The agent found that the offer made by the defendant was the highest but less than rupees 700 of the original agreement. The agent accepted the money and gave in writing that the payment was a full settlement of a claim of plaintiff against the defendant. The plaintiff, having accepted the money, brought an action against the defendant for the recovery of balance amount of rupees 700. The question had arisen before the court was, did the agent in this case has an implied authority to accept the smaller amount of money from the defendant in settlement of the whole claim? The court held that under section 188 the agent has an implied authority to accept the smaller amount of ready cash with abandonment of a claim for money by the principal against the purchaser. Hence, the plaintiff action failed. The authority of the agent even extend to the acts which were prohibited or restricted by the principal unless the third person knows such prohibition or restriction. Agent's authority in an emergency. Under section 189 of the Act, the agent is empowered to exercise such authority as a person of an ordinary prudence in his own case under similar circumstances to do all such acts for the purpose of protecting the principal from loss in cases of emergency. Example, if A sends some provisions to B at Kolkata with direction to send them to C at Cuttack immediately, but B sells them at Kolkata as they were not in a position to bear the journey to Cuttack without spoiling them. The power under this section also arises where there is no express or implied appointment of a person as agent of another, but he is forced to act on behalf of a particular person. Example, a person is authorized for a repairs if that be necessary to carry out the sale. Principal bound by estoppel. Under section 237, where the agent is neither expressly nor impliedly authorized to do act on behalf of the principal, but the principal creates an impression in the mind of the third person to believe that an agent has an authority to act on behalf of the principal. In such case, the principal is bound by such acts of the agent against third person under the law of estoppel. The basis for the action is apparent or ostensible authority conferred on the agent. Principle bound by ratification. According to the general principles of agency, we have learned that the principal is bound by an act of an agent which has been done under his authority. But if the agent does an act which he does not have any authority, then principal is not bound for the same. To this general rule, there is an exception when the principal may be bound even for the acts done by an agent without his authority if the principal ratifies the same, that is, accords the subsequent approval. In this principle, though act has been done without the authority of the principal but done on his behalf, make the principal liable against the person. The provisions relating to ratification are dealt under sections 96 to 200 of Contract Act, where the right of a person to ratify the act done on his behalf and impact of ratification are discussed. Under section 196, the person on whose behalf an act is done without his knowledge or authority has two options: to either to disown the act or to ratify the same. Person represent himself an agent of another person and induce the third person to deal with him is liable personally for the compensation arising out of damages or loss incurred by the third person if his alleged principal does not ratify the act. On ratification, the principal bounds the act of another even if the act was done without his authority. Otherwise, he even may disown the act where his liability comes to an end. Hence, ratification means according approval to the act by a person on whose behalf the act is done. According approval or ratifying makes the person doing so as principal, and the person who has done the act becomes the agent. After the ratification, the validity relates back to time of doing it. Essentials of valid ratification. First one, the act should be done on behalf of another under section 196. Second one, the principal must be in existence and competent. Third one, ratification may be express or implied under section 197. Fourth one, ratification should be with full knowledge of facts under section 198. Fifth one, ratification should be of the whole transaction under section 199. Sixth one, ratified act should not be injurious to the third person under section 200. And seventh one, ratification should be made within a reasonable time. Section 196, act should be done on behalf of another. Where the act is not done on behalf of another who seeks to ratify it does not amount to ratification. In Kigley, Maxted and Company versus Durant, the question of agent acting on his own account cannot be ratified was explained. In this case, the plaintiff has instructed Robert to buy some wheat on joint account, that is by them and himself at certain rate. Robert purchased the wheat for slightly higher price in his own account because of non-availability. It was purported to ratify the agreement, but later the plaintiffs refused to take the delivery of wheat. Action was brought against the plaintiffs for the breach of contract, where it was held that the plaintiffs could not be made liable as the act of Roberts does not bind them as it was done on their own behalf. The principal must be in existence and competent. According to the principles of ratification, it comes into effect from the date of a contract entered with a third person by an agent. Therefore, it is condition precedent that at the time of ratification, the principal must be in existence and competent. This was explained in the Kellner versus Baxter. In this case, the promoters of the company entered into a contract on behalf of the company before its formation. After the formation of the company, the said contract was ratified. Later, the company went into liquidation. The suit was fixed, making the promoters liable for the contract. The promoters contended that they were not responsible as the contract was ratified by the company. The contention was rejected and held that at the time of the ratification, the company was not in existence and purported ratification was nullity. Hence, the promoters continued to be liable. Ratification may be express or implied. According to section 197, ratification may be express or implied in the conduct of the person on whose behalf the acts are done. Example, A, without B's authority, lends B's money to C. Afterwards, B accepts the interest on the money from C. B's conduct here implies a ratification of the loan. Ratification with full knowledge of facts. Under Section 198, no valid ratification can be made by a person whose knowledge of the case is materially defective. In Savary versus King, A in this case entered an agreement on behalf of B which was invalid. Without knowing this fact, B purported to ratify the transaction. It was held that since B was not knowing about the invalidity of agreement, the purported ratification of the same by him was of no effect. Ratification of the whole transaction. Section 199 deals with the effect of ratifying unauthorized act forming part of the transaction. The section says person ratifying any unauthorized act done on his behalf ratifies the whole of the transaction of which the act performed a part. The very object of this section is that no principal may ratify only those part of the transactions which are favorable to him and disown others. If he makes ratification, it deemed to be the ratification of the whole act. The act should not be injurious to a third person. According to Section 200, ratification of an act is done without authority of a person if it would result in injury to the interest of the third person. Such ratification would be invalid if ratified by the person. Example, A not authorized by B thereto demands the delivery of a cattle, the property of B from C who is in actual possession of it. This demand of A cannot be ratified by B so as to make C liable for damage for his refusal to deliver. Ratification within a reasonable time. For the ratification to be valid, it is relevant that the ratification must be done within a reasonable time. The unreasonable delay in ratification could be detrimental to the interest of the third person. The fifth mode of creation of agency is by presumption of agency in husband-wife relationship. Agency in the relationship of a husband and a wife arises either by cohabitation or by necessity. It is an agency by cohabitation when a married woman and cohabiting with her husband is presumed to have the power to pledge the credit of her husband for necessaries according to the life of the family. Hence, the authority is presumed to be there when the husband and wife are cohabiting in a domestic establishment. And agency by necessity arises even if the husband and wife are not living together, she could pledge the credit of her husband. Such authority was presumed when neither the husband was supporting her nor had she the means of supporting herself. However, there is no such agency in India as a wife can claim maintenance under her personal law. We are going to discuss impact of ratification, that is doctrine of relation back. The ratification of the act by the principal done on his behalf without his authority or knowledge, the effects of it are same as if the act of ratification was performed with the prior authorization of the principal under section 196. The date of contract by the agent and not the date of the ratification by the principal is the date of entering into the contract. In Bolton Partners versus Lambert, where the managing director of a company sells sugar to A on behalf of the company without any authority on 1st January, the company tries to ratify the transaction on 1st February, but on 15th of January, A wants to withdraw his offer. He cannot because by subsequent ratification, the contract is deemed to have made on 1st January and it was held that there can be no withdrawal of offer after that. But the position is different if the agent purports to make the contract subject to ratification by the principal. In such a case, the date of making the contract is date of the ratification, and in such cases there can be a possibility of revocation of the offer before the ratification. Hence, under the above circumstances, the principal would be bound by the act of an agent.